So for those of us that are just joining us, welcome to the Silicon Flatiron's annual privacy conference this year, focused on privacy at the margins. We've had a simply fantastic morning, and it just keeps getting better and better. And it's my real joy and honor to introduce today's keynote speaker, Dr. Anita Allen. Dr. Allen is the Henry R. Silverman Professor of Law and Professor of Philosophy at the University of Pennsylvania, and she served as Vice Provost at that institution for 7 years. Dr. Allen's a graduate of Harvard Law School, receiving her PhD in philosophy from the University of Michigan. She is a global thought leader in the fields of privacy law, data protection, in ethics. Her scholarship is foundational in the area of privacy and discrimination. Among her numerous publications include several books, including Unpopular Privacy, What We Must Hide, The New Ethics, a guided tour of the 21st century moral landscape, and why privacy isn't everything. She is widely cited, has visited schools across the globe, and we are extremely lucky to have her as our keynote speaker tonight. For me, this is a real honor. Ever since I was first started in academia and started thinking about privacy, Dr. Allen's books were some of the first I read, and I've gotten to meet her in passing at a couple privacy conferences, but I was so thrilled when she accepted this invitation. So Dr. Allen, thank you for taking the time to share your thoughts on privacy through an African American lens. Dr. Allen's going to talk for about 30 minutes, and then we will have 15 minutes of question and answer. So with that, Dr. Allen, thank you for joining us.
Thank you so much for inviting me. This is such an honor. As you can hear, those of you who don't know me, I've been around for a long time. If you can think about someone who started college in 1970, you can kind of guess my age. But it's been fascinating to watch this field grow and develop. And I'm jealous of the younger folks, but for one reason, and that's because I would have loved to have had brilliant allies like the folks that we just heard on the previous panel to join me in my early efforts to sort of slog through the concept of privacy as it applies to the law. So I'm going to use some slides today, and let me just make sure I can screen share and I can get right started. Let's see, there we go. All right, I think we're right here. Okay, thank you. So I am a lawyer, as was just mentioned. I'm also an academic philosopher, and my special interest is in the ethical and legal dimensions of privacy and data protection. Since the 1980s, I've been interested in the privacy of marginalized populations. So I'm thrilled, of course, by this conference and by the work of Scott Skinner Thompson and his important book, Privacy at the Margins, which had a huge impact on sort of propelling me to make this one of my primary concerns. So thank you, Scott, for your leadership. In my very first book, and this is one that Scott didn't mention, Uneasy Access, Privacy for Women in a Free Society, I included chapters about how lawyers and philosophers define privacy and how it has value and why it matters practically and politically. I focused at that time on the rights of women and the feminist critique of privacy with the feminist critique of privacy sort of as my focal point and insight. And I wasn't just focused on the privacy of middle-class white women, but also on the privacy of women of color and poor women as it relates to issues like birth control and abortion, also freedom from sexual harassment, and the privacy rights of sex workers. In the early 1990s, I started to think more about the history of privacy law. And I wrote an article called How Privacy Got Its Gender, about the role that concerns about women's modesty and our privacy played in shaping the development and growth of American privacy law. And that role was huge. If I'm not mistaken, I may have been the first person to really analyze the issues of gender embedded in the famous Warren and Brandeis Right to Privacy article from 1890. So after I wrote that article, I also began to focus on the rights of women of color who were being asked to serve as surrogate mothers and surrogate gestators back in the 1980s and early 1990s. And then the internet happened and the web and social media. So in response to these newer concerns, I shifted my focus. I wrote an article called Women and Privacy in Cyberspace, arguing that women are vulnerable to privacy invasions in cyberspace, quite analogous to those that they experience in the non-digital world. Something I'm sure is also true of LGBT persons. So never really forgetting, though, the offline world, I've written about the usefulness of the privacy tort for LGBTQ plaintiffs and why HIPAA doesn't necessarily entail robust medical privacy rights for women. Well, something big happened in the world last summer that changed the focus of my work. So last summer, the protests and riots that broke out across the country were truly upsetting. And the George Floyd murder, broad daylight by a Minnesota police officer who pressed his knee into Floyd's neck until Floyd stopped breathing. The officer claimed that he was just doing what the US Constitutional Bill of Rights allows him to do, which is to seize a criminal suspect. Breonna Taylor, an innocent Black woman, was shot by the police who burst into her apartment late at night looking for evidence of drug crimes by her ex-boyfriend. Well, I realized that after these upsetting incidents that I hadn't spent sufficient time looking at privacy through the lens of race and the intersectionality between race and gender as it relates to privacy. There were a couple of exceptions that I could give myself as I was scolding myself. One exception was that I did write a chapter on racial privacy in my book, Unwanted Privacy. And in that chapter, I did about the idea that we really don't want to, we love the Europeans, we love the EU Privacy Directive and the GDPR, and we think that they're superior regimes in many respects to our law. But there's one respect in which I think we shouldn't copy the Europeans, and that is in treating race as a sensitive category and denying folks the ability to use race for remedial purposes. So I wrote about that. And then in my book, Why Privacy Isn't Everything, which thank you, Scott, for mentioning, I talked about accountability. And everybody likes to think that privacy is everything, but of course it isn't. We are accountable to other people. And in particular, I suggest we're accountable to people of our own race and ethnic groups, and sort of point out some of the social norms that suggest a kind of cultural accountability that does go along with racial groups and ethnic groups as such. So this afternoon, in the little time that I have, I'd like to share with you some examples of what I'm seeing and increasingly thinking about as I look at privacy through the lens of my race and my gender. I'm led to propose a different way, a bottoms-up way of thinking about the task of defining what privacy means, that I call this approach critical definitional facilitation. And the top-down approach that I reject, I'm going to describe as definitional prescription. These techniques, these methodologies have served as barriers actually to people with backgrounds in philosophy like me, getting beyond the ivory tower into the world to make the world better. We need to stop focusing so much on analytic definition of the word privacy and more on doing justice for marginalized peoples. So we're living in a digital age, of course, and we're all concerned about the weaponization of technology. We're worrying that our society has become a Benthamite Panopticon, and even worse, what's being called the Panopticon, in which the legitimate interests of marginalized groups are forced out of the sightlines of civil society. Privacy can mean power, as illuminated by Carissa Velez. It can also mean the lack of power and powerlessness. Technology can be a benefit to women of color and women of all backgrounds and people of color, but it can also be a problem. But in terms of it being a benefit, many have pointed out that technology has enabled greater solidarity and greater ability to watch the watchers and greater ability for us to deter and to document some atrocities. But again, technology can be and often is a tool of domination. So today, looking at privacy through the lens of race. There's so much to consider, and this conference has brought out some of these points very, very well, and will continue to do so. But let me just give you my summary of what I think we're all thinking about as we think about privacy through the lenses of race, gender, LGBTQ, trans, poverty, etc. So the extent to which privacy is a commodity more available to the wealthy and privileged classes, that's one concern. Another is whether race should be considered private and sensitive as it is in the EU. How people dependent on government benefits and programs are required to sacrifice privacy and private choice. How mass incarceration has meant lives without privacy or the wrong kinds of privacy, meaning isolation in solitary confinement and supermax confinement. How the affordability of privacy protecting technology impacts the distribution of data privacy. How big data analytics rely on algorithms potentially unfair to minority races. And finally, how surveillance technologies, including social tracking, street cameras, body cameras, facial recognition, spy planes, unfairly target minority populations, undermining freedom. So quite a huge agenda when we began to look at privacy through the lens of race. But when you look at privacy through the lens of race and female gender, what one sees are stories of both victimization, but also of agency. And I think we need to talk more about the agency side of all of this. So looking at privacy through the lens of race and gender in an American context is an opportunity to celebrate the ways in which Black lawyers, Black NGOs, and ordinary Black men and women facing unjust prosecution have led to landmark legal rulings that benefit everybody. So Thurgood Marshall and the NAACP brought the landmark case NAACP versus Alabama, in which the US Supreme Court found that the First Amendment protects associational privacy. Tyrone Garner, one of the petitioners in Lawrence versus Texas, was a Black man, and that case decriminalized gay sex in the name of 14th Amendment, equal protection and privacy. Shown on the slide, a humble Black and Native American woman illegally married to a white man was behind Loving versus Virginia, the case that decriminalized interracial marriage and set the stage for the decriminalization and the illegality of and the legalization, excuse me, of gay marriage, same-sex marriage. So I could go on, but clearly these are examples where brave men and women launched legal battles that resulted in additional privacy, not just for them personally, but for everybody, for people of all backgrounds and races. On the other side, many of our famous criminal procedure cases involve Black petitioners that in effect serve the role of helping to create more restrictions on police power and benefit lots of people, including people of color. So Dalry Mapp was the petitioner behind the Mapp versus Ohio case. That was the case that led to the exclusionary rule that evidence acquired in violation of the Constitution is inadmissible in a criminal prosecution. So we have our heroes. We also have our scholarly heroes and heroines of color, from Oscar Gandy, who wrote an important book called Panopticon decades ago, to Simone Brown, who wrote the wonderful book Dark Matters. So Simone Brown's work is very arresting. And from her, I actually learned, I'm a philosopher, but I learned from her that the British philosopher Jeremy Bentham wrote the Panopticon letters describing methods of efficient observation and control of persons in confinement while he was on a ship with a cargo of Black women slaves, Black women enslaved persons. As suggested by 20th century judge, by a particular 20th century judge who started the legal right to privacy as a positive law matter in the United States, privacy deprivation is a kind of slavery. And I think that it was very telling to me that Simone Brown tried to link the concerns of our surveillance society with slavery. And I'm doing the same thing with you today. I'm linking the normative, the philosophical values of privacy with our opposition to the horrors of chattel slavery. So in 1905, you privacy scholars know this, Patches versus New England Life Insurance Company became the first American state court case to find that there's a legal right to privacy in common law. This opinion was based in part on the work of Warren and Brandeis, who argued for a right to privacy that was a right to, quote, be left alone. So Warren and Brandeis, they spoke from a throne of privilege, and they talked about inviolate personality and man's spiritual nature. But the Pabst's case talked about slavery. So if you look at the opinion that Judge Cobb wrote, he despite the fact that Judge Cobb was the son of slaves, the grandson of slaves, the nephew of slaves, the nephew of the man who wrote the Confederate Constitution, he understood that privacy invasions, even ones like the one in the slide showing the man, Mr. Pabst, who woke up one morning and found his photograph used in an ad for insurance in the Atlanta Constitution newspaper and brought lawsuit. Even that kind of violation has an affinity to slavery, because so in the words of the judge, the knowledge that your features and your form are being used and displayed brings not only a person of extremely sensitive nature, but even the individual of ordinary sensibility to the realization that his liberty has been taken away from him, and that as long as the advertiser uses him, and I underscore the word uses him for these purposes, he cannot be otherwise than conscious of the fact that he is, for the time being, under the control of another, that he's no longer free, and that he is in reality a slave without hope of freedom, held to the service by a merciless master. Now, years ago when I read this case for the first time, it almost offended me that the judge would analogize having your picture used in an advertisement with chattel slavery, the horrors of which are shown here on the slide. The picture of Gordon, the enslaved man who ran away with the scars of physical abuse that became such a famous a photograph and a famous sort of cry for the end of slavery and similar institutions. But there is a connection. I just want to draw that out a little bit today. So in the meantime, though, we find that in the world of tech talk and in the world of privacy talk and discourse today, that many people, whether they're tech innovators or government and officials or revenge pornographers, they like to silence privacy discourse by claiming that people are consensually giving up their data. I had permission to post those images of my ex-lover on the internet, or she gave me or they consented to terms of service, and so my using their data is not a violation of their privacy rights. But that kind of consent talk should not intimidate us, because we know that the discourse of consent was actually used to defend slavery itself. There were many philosophers who in the 17th, 18th, and 19th century wrote about slavery, argued that from a sort of social contractarian point of view, that slavery was the best deal that inferior Africans could expect to get. They were lucky to be able to be rescued from their savagery, and they in effect consent to the superior domination of white races. So we shouldn't let consent talk, even today, cause us to think that we have a reason to be shut up and to stop talking about privacy. And then there are also people, especially in philosophy, who claim that the term privacy is confused, ambiguous, vague, marginal, obscure, unnecessary, overbroad, non-paradigmatic, elusive, nonsensical, unclear, contradictory, and meaningless. And they suggest we should use other terms instead. Again, trying to deprive people for whom privacy is a powerful discourse from using the discourse. And so a very popular strategy is to claim that privacy is intractably vague, and therefore we can't use it in trying to develop policies, especially in the digital age. Concepts like de-identification, and as well as the no privacy in public idea, are similarly used as ways to try to deprive people conceptually of the ability to use privacy discourse. And this is something which we must fight, and that I, as a philosopher, am particularly concerned about trying to fight. And again, the whole slavery analogy point to me is consistent with the strong privacy message of Shoshana Zuboff in The Age of Surveillance Capitalism, where she talks about the the ways in which we're losing control over data, and it all has to do with the foundations of capitalist thought and practice. But in her recent New York Times article, she made a very interesting point about how there is actually a knowledge coup going on. She saw, as we all did, the January 6th coup attempt on our federal government, on our Congress, and she said, well, there's another coup going on that we're not paying as much attention to, and that's the knowledge coup, represented by the ways in which we're allowing and our privacy, our information to be taken away, that technology is using us, and we're using it, but it's using us in ways that quite literally threaten to seize our democracy. So I think that we need to start to think about privacy, that the history of privacy and the growth of privacy law and privacy law itself in a different way. To not start with the Warren and Brandeis story about cameras and newspapers and tabloid journalism, but to instead start with the image of slavery. So I'm starting to tell the story of privacy now by beginning with the story of Lydia, a case called State versus Man from the early 19th century, the 1820s. This is a case brought by a petitioner who was a white man who believed he'd been unjustly convicted of having shot and wounded an enslaved woman. But Lydia was the hero here. She was attempting to run away from a man who was beating her. She'd been hired out to this guy. He was beating her unjustly, she felt, and she tried to escape. He shot and wounded her. The white community didn't think he should have shot her. They made sure he got prosecuted, but the North Carolina Supreme Court overturned his conviction. And he did so using the language of privacy, arguing that to prosecute the white man for shooting the enslaved woman would be to undermine the privacy of the slave master relationship. And that same Supreme Court in North Carolina, a couple of decades later, used similar reasoning to justify not prosecuting a white man who had beaten his woman. State versus Rhodes. Mrs. Rhodes brought a suit against her husband for assault, but the court said we can't interfere with the privacy of marriage, the privacy of the domestic life. And so we saw, as a beginning, privacy discourse being used against marginalized peoples, which we must never forget. But at the same time, we must remember that the point that we were attempting to make, that was attempted to being made long ago, is that marginalized people do have important rights. And among them today, ironically, is the very right to privacy that their masters and their husbands had and wielded against them in the 19th century. So continuing the story of privacy law, right? We all know the story of Rochester versus folding box company and the beautiful young woman whose picture was on a box of flour. Roberson versus Rochester folding box company. Excuse me, I think I misstated the case name. Roberson versus Rochester folding box company. Beautiful young white woman. Her picture used without her consent on a box of flour led to a big flap that led to us to have the famous New York civil rights laws that protect people from having their images, their names and likenesses and identities appropriated for commercial purposes or trade purposes in New York. So that law stands. But what scholar Eden Osuka has pointed out is that about the same time, and even before Roberson, there were many dark-skinned, obese Black women being used by the Aunt Jemima pancake flour company to advertise pancake mix, and nobody was alleging that there was something unseemly, improper, immodest, or private about the Black woman's image that should cause reluctance to put her out there selling pancake flours at expositions, fairs, and also having her picture on the box. There's a whole stream of Black women who played the Aunt Jemima role, including the first one who had been a former enslaved person. So, we're working on sort of two fronts here. One is trying to retell the history of privacy in a way that foregrounds the struggles of marginalized people to be heard, right? To get attention, to be heard. And I'm emphasizing here again, African Americans, the women, but one can emphasize other groups that have been similarly left out. And then the second front we're operating on here in my talk is trying to deal with the fact that philosophers have, I think, let us down, and they fussed over the definition of privacy at the expense of turning their attention to the real problems in the world suffered by people of color who would like to use the privacy discourse, but who are being told that their concerns about things like, again, like about arrests or marriage rights or abortion rights, those aren't privacy concerns at all. So I was very happy to see a couple of years ago when the Indian Supreme Court in the Puttaswamy decision, Puttaswamy versus Union of India case, that case was the landmark case that created the right to privacy in India for the first time. And the right not only opened the door to more restrictions on biometric identification-based ID card in India, but then 1 year later, that same decision was used to decriminalize gay sex across the nation of India. And I was pleased that the court acknowledged all these philosophical debates by lawyers and philosophers over what privacy means, but they didn't stop to fuss over those definitions or to view their job as harder because people don't agree about how to define the word privacy. They just got the job done. They got the job of putting restrictions on a biometric ID card, and they got the job done essentially of also opening the door to more freedoms for LGBT people in the nation of India, one of the most populous countries, of course, in the world. So what I think the problem has been on the philosophical level is exemplified by this slide. If you read the bottom of the slide, this is how a typical analytic philosopher talks about privacy. So you have someone like William Parent saying that he proposes it to define privacy as ... and he goes on to give a definition of privacy. And the definition he gives as undocumented personal information, being had by others. It's like, your eyes glaze over as you think about Trayvon Martin or George Floyd. How do we get from the ivory tower task of defining the necessary and sufficient conditions of using the word privacy, a prescriptive definition on that analytic problem, to addressing the urgent problems faced by marginalized people? How do we get there? Well, I have a thought about how we get there. I would propose that our approach be instead one that I call critical definitional facilitation. And here we don't start with prescriptive definitions of privacy like the one we saw on the last slide by William Parent. Instead, we assume that privacy discourse belongs anywhere there's an assault on or a diminution of the person that threatens to use us, to use people or treat people as if they were slaves. And that we attack problems after we've identified them, and that we define privacy pragmatically as we go along, as we need to. If in order to get a legal matter involving a Trayvon Martin or a Breonna Taylor or another person before a court, we need to have some definition of privacy. Let's just stipulate one that can kind of get us through the door and we get the job done, not to be to be confined by or constrained by the need to find a definition. And philosophers often act as if somehow courts can't operate unless they have a precise definition of privacy. That's not true of privacy. It's not true of the word equality. It's not true of the word solidarity. It's not true of the word liberty. But for some reason, a lot of people think that somehow we have to define privacy before we can move forward with an affirmative progressive agenda. We don't. I think that the work of Kiera Bridges has been very important in terms of helping us to see that there can be a poverty of privacy rights if, in fact, they're not privacy rights are not utilized in the right way to help people who are dependent, especially upon government services, et cetera. But privacy rights don't have to be impoverished; they can be quite strong, and we can not yield to the notion that somehow if we're stuck with thin negative liberties and that's all we've got. I think we need to think about ways to continue to rehabilitate privacy discourse and to use it, because it is a powerful discourse, and people do often feel as if the main thing that's wrong in their lives is that they don't have enough privacy and private choice. The problem of facial recognition is just one of the great example of what's going on today. The ways in which people feel that their privacy and their liberty is assaulted by these technologies that don't work that well. Najir Park spent 10 days in jail, 10 days after being misidentified by New Jersey police using facial recognition technology. He was accused of having stolen some candy from a hotel and having crashed into a police car. Guess what? He'd never been to the town where the theft occurred, Woodbridge. He didn't own a car. He didn't own a driver's license. He had an airtight alibi. He still spent 10 days in jail, despite things like fingerprinting that might have proven that he wasn't the person that they were actually looking for. We've seen from the brilliant work of Joy Buolamwini at MIT that facial recognition technology is very bad at discerning skin color, discerning one person of dark skin color from another person of dark skin color. It's also very bad at discerning dark skinned people's genders. If you're just in kind of a binary world of male, female, well, this technology she's shown is very bad at discerning male versus female faces when the males and females are dark skinned. There's something like a 34% error rate versus a 1% error rate for people with lighter complexions. Yet this technology is being weaponized against Black people all the time. Thank you for what's happening in Oregon and some similar jurisdictions. It's being used less often or not at all. So rather than like marginalize the concerns of women of color and people of color generally, the philosophy of privacy should, as I said before, begin with the story of the ways in which privacy discourse was used at the beginning of our country and move up to ways in which the discourse of privacy has been adopted and by minority cultures and used by people of color to do good work, as it was, in the 1950s by Thurgood Marshall, as it was in the Roe versus Wade context, as it was in the context of our getting greater rights for LGBT sex and same-sex marriage. There are some, examples I could give of abuses of Black folks' privacy, with Black women's privacy that do strain what we mean by privacy. But I think you could sort of see the Henrietta Lacks story, which is a story of the woman who, whose DNA, whose cells from her cervical cancer were used in research for many years before her family found out. Basically, she had a very bad case of cervical cancer. In her surgery, some of her cells were sent to a scientist working on trying to preserve the life of cells in the lab. He found that her cells were incredibly reproductively magical. They would be produced again and again and again. So her cells have had a kind of immortal life, hence the name of the book by Rebecca Sloot. But in any event, her bodily integrity and in some ways her privacy in the sense of the right to choose, the right to have informed consent was violated, as was that arguably of her family after her death. Again, we're sort of using the discourse of privacy here in ways which some philosophers would say it's confusing, vague, etc. But again, if you foreground the problem and not the definition of the term, we can get the work done. Right. And so her family's been fully compensated for the wrong done to her, which is a good thing. Thank you, Johns Hopkins. Another point I want to make briefly here is about the ways in which even when we have strong privacy laws, they don't work the same for people of color, for women of color in particular, and women. So these are two examples I could give. We have Dr. Nikita Levy, who is a OBGYN affiliated with Johns Hopkins. For years, he saw patients, around 8,000 different women, and he had these little spy cameras and spy pins in his office, and he was basically videotaping or videoing his encounters with women. So their breasts, their genitalia, their examinations, their conversations were recorded, and he was serving all this stuff up on a bank of computers he had in his home to the internet. When he was finally detected, he was so ashamed of himself, he actually committed suicide. The women who were affected eventually got settlements from Johns Hopkins, ranging from a couple of tens of thousands of dollars to over $1 million each. Then we have the scandalous case of Dr. Larry Nassar. He, like Dr. Levy, lived in a HIPAA world. We have this federal statute, the Health Insurance Affordability and Accountability Act. It has privacy and data security regulations attached to it. But those kinds of laws don't work to protect women if the healthcare providers simply do not respect women. And so Nassar didn't respect the young women that he was treating, and Levy didn't respect the young women and older women and women of color that he was treating in his practice in Baltimore. Another sort of weakness of privacy law for people of color can be shown in the case of Chantelle Jackson. She was the girlfriend of a prize fighter, Floyd Mayweather, who posted online intimacies about their life, including an image of an ultrasound of twin fetuses that he claims were aborted. But her privacy claims in court were not very well treated. The judge threw out all of her privacy claims, except for one relating to the ultrasound. But her own privacy claims about her cosmetic surgery images being put out there on the internet by her disgruntled ex-boyfriend, the court just threw those out, claiming that, well, you know, people like her, celebrities, they're on the internet all the time, they live for social media, they don't have any privacy rights worth protecting. And then finally, I think that we should talk a lot more than we do in the privacy world about sex workers, as was mentioned in the previous panel. A lot of times the sex workers' rights are defended under the banner of personal autonomy and privacy. While that liberal dream is questioned and criticized, it's a very real consideration as to whether or not the decriminalization movement or the lack of it violates women's privacy and personal autonomy, and sex workers who are men, their privacy and sexual autonomy too. And in terms of marginalized people, I'll just note here that France, when it introduced a new law recently, it estimated that 90% of the country's sex workers were victims of Nigerian, Chinese, or Romanian trafficking networks. Again, talking about autonomy and privacy here, where privacy has a very complicated and nuanced set of meanings. So I've gone on a bit too far, but basically, you know, I think that we should you know, define privacy by reference, first of all, to the problems we want to solve, and that we should understand that basically the mandate to do justice through privacy discourse is all about the values that I have on the slide, including agency, power, non-exploitation, autonomy, homes and families of one's own, if that's what one wants, limited government, and in the final analysis, justice. So I will shut up there, and we have time for a few questions. And thank you, Scott Skinner Thompson, for giving me what I think was a little bit extra time there, but thank you so much.
No, of course. Thank you so much, Dr. Allen. That was absolutely breathtaking. And you're just, yeah, I mean, so many great points, but the emphasis on starting with what we can learn from marginalized community about why privacy matters, and it matters because it's visceral, and you painted such a vivid picture of that was incredible. So thank you for concretizing privacy harms. To get us started in terms of questions, we have a student here at Colorado Law School, Lily Wasser, who's going to ask our first question. Go ahead, Lily.
Hi, Dr. Allen.
Hi, Lily.
Thank you so much for your presentation. I just wanted to kind of ask a little bit that one of the earlier panels on racial and immigrant discrimination was talking a lot about how there's kind of a lack of understanding and literacy among a lot of these communities who are affected. So how do we take this kind of broader philosophical conception and break it down so that you also talked about identifying when we cross those privacy lines in these communities, and using those to kind of create new cases and move privacy forward for these communities. So how do we cross that boundary between literacy and understanding privacy, and understanding how privacy is being invaded in order to bring this forward?
Yeah, so there's a lot of education that needs to go on. I think that lawyers like ourselves need to be educated about the communities whose privacy and related rights are being compromised, so that we can help them. And once we identify populations that we think we want to help, if we feel that the population needs more information, we can try to give it to them. It's interesting about how educating people might affect their interest in having their privacy rights protected or not. There's a very interesting study that I read about a project where they want to know how people's understanding of their privacy rights might affect their willingness to serve in human subject research. To targeting low-income minority women, they asked them about their willingness to participate in the study. There was a control group that was right away told about HIPAA and about their privacy rights, and a group that was not educated about HIPAA and their privacy rights right away. The group that was educated about their privacy rights, they were more likely to decline participation in the research than the group that didn't get the information. You might think the opposite. Oh, well, if people knew their HIPAA rights, their privacy rights, they would be more willing to participate. But the opposite was true. And so I think that there's this. Not only do we need to be educating, figure out ways, and I'm not answering your question probably the way you hoped I would, but ways to address the problem that you identify, which is informing people about the rights that they do and don't have, and also eliciting from them what their privacy values are, because we don't want to impose, our bourgeois liberal privacy values on populations that don't share quite those same values. I mean, there are some variations, right? But the thing that I want to emphasize in response to your question is that yes, we do have an obligation to try to educate. That might mean that we're surprised, right? And what do you do when you're surprised? How do you show respect for marginalized populations when they don't respond to privacy information exactly as you would like them to, or you would hope they would, right? That's a reality we have to learn how to deal with. I thank you for your great question.
Thank you.
Thanks to you both. Another question from an audience member about how we got here. Like, why is it that we have sort of slogged through with these prescriptive definitions of privacy for so long? Do you think that is just why do you think we've sort of had to go through that? And do you think that this is unique to the context of privacy, or do you think that other areas of law are similarly burdened by abstract notions of our different constitutional, with a lowercase c, values?
Well, there's an interesting question as to what contribution the discipline of philosophy, as compared to history or literature or economics or political science, what can philosophy offer the world, right? And oftentimes philosophers self-define as the armchair critic who simply take information and try to clarify and analyze what's going on in the world without any sense of outreach or impact of their work. So one of the things which I've tried to do as an applied philosopher is to cause philosophers to understand that they can and should do more by way of trying to positively impact the world, to get out of the armchair and to not prioritize the analytic methodology that they do in such a way that then they do nothing else. They just years and years and years of analyzed necessary and sufficient conditions for something to be an example of something else. A lot of it has to do with the dominance of Oxford, Cambridge style analytic philosophy, which took a grip on the United States in the 1970s. It was the way to do philosophy. It wasn't a practical discipline. So people like me who have bridged philosophy and law are the ones, I think, who are most likely to say, yeah, it's important to have conceptual clarity, but people are dying. People are literally dying out there because their Fourth Amendment privacy rights are not being respected. People are dying out there because their right to abortion and birth control are not being respected. And you're saying that those aren't privacy matters? Why aren't you instead trying to get the law changed under a privacy rubric or under some other rubric? But it's really a problem, Scott, I think, of how a discipline defines itself, and a philosophy traditionally being too comfortable being simply an armchair, ivory tower enterprise.
Thank you for that. And the last question, another interesting one, asking about whether you could engage with Shoshana Zuboff's argument about how there's this extraction, right? Of data is occurring. Everybody's impacted by that, right? It's not just marginalized groups, and so do you think that that widespread surveillance of all aspects of society changes your analysis or not, and why?
Well, everybody is having their data compromised, not just marginalized people, absolutely. but there needs to be strong voices for focusing on the ways in which the problems that everybody is facing also impact people of color, and often impact them in worse ways than other groups might be impacted. So it's that margin of difference, right? That we need to be focusing on. So for example, when Baltimore decided to use spy planes to fly over the city in order to deter or detect crime, they deliberately focused on the minority communities. They could have flown over they could have focused on any neighborhoods when their spy plane. So the spy plane, in theory, impacted everybody in Baltimore, but the authorities chose to target the planes spying on certain marginalized communities on the assumption that that's where the crime that needed to be addressed was going to be found. That's the difference, right? So everybody's affected, but then some people are affected more, right? So doctors can have spy pins in their camera, but which patients are most likely to have their vaginas and their breasts photo? Well, it's going to be the doctor who doesn't respect women. It's because we're women, and poor women oftentimes, that we're seen as easy targets. Oh, they'll never catch me because my victim is a woman. And the same thing happens with sex workers. So everybody can experience problems of sexual violence, but some communities, the trans male community, the trans female community, sex workers in general, are more impacted than everybody. So that's where I think we need to focus. And I don't think that that's inconsistent with Shoshana's work, but I think that we shouldn't let the problems of the margins get swallowed up by the center. But I think it's one of your messages too, Scott, right? The center shouldn't swallow up the problems of the margin, which are similar but also different.
That's right. No, and that's beautifully, characteristically beautifully put. And Dr. Allen, thank you so much, not just for joining us today, but for your insightful work you presented today, but your legacy of work on this topic as well. So appreciate it, and look forward to future engagements as well. Folks, we're going to take a bit of a break, allow people to take care of some concrete needs, get some food and lunch and water, and we will be back in 45 minutes for our last panel on the costs of privacy, surveillance of the poor, and then some what promises to be excellent closing remarks from our executive director here at Silicon Flatirons, Amy Stepanovich. So thank you all for your participation, and we'll see you back here at 1:30 Mountain Time.